The Supreme Court has stayed its November 20 judgment that accepted a 100-meter elevation criterion for defining the Aravalli Hills, amid nationwide protests by environmental groups. What it is? The stay pauses the court's earlier acceptance of the Union government's height-based definition of the Aravalli Hills, landforms is greater than or equal to 100 m above local relief, for regulating mining. The interim order restores status quo ante, preventing immediate regulatory dilution while the court re-examines ecological and constitutional implications. History of Supreme Court interventions on Aravallis, Godavarman Tirumupad vs Union of India, 1995 ongoing, expanded the definition of forest beyond records to ecological characteristics, bringing Aravalli forests under judicial protection and regulating mining and construction. MC Mehta vs Union of India, 1985 ongoing, became the principal vehicle for Aravalli protection in Delhi, Haryana, leading to bans on illegal mining, construction controls, and demolition of unlawful real estate. Mining prohibitions, 1996 to 2002. The court banned mining in parts of Faridabad and Haryana Aravallis based on expert reports, HPCB, NIRI, recognizing irreversible ecological damage. 2010 FSI Scientific Survey Order, rejected the 100-meter height rule and directed FSI to map the entire Aravalli range using scientific parameters, leading to the 3-degree slope plus buffer criterion. 2018, Vanished Hills Intervention, acting on CEC findings that 31 of 128 hills had disappeared, the court ordered immediate stoppage of illegal mining, prioritizing ecology over royalty revenue. Delhi Ridge Protection, 2023 to 2025, recognized the concept of morphological ridge, barred land allotment, halted tree felling, and ordered statutory backing for the Delhi Ridge Management Board. Judgment Conundrum, Scientific Reductionism, a single elevation threshold ignores low-relief hills, pediments and ridges that perform vital ecological functions like groundwater recharge and climate moderation. Departure from functional ecology. Earlier jurisprudence assessed landscapes by ecological function, not numerical metrics, raising concerns of doctrinal inconsistency. Article 21 Implications. As held in Subhash Kumar vs. State of Bihar, 1991, the right to life includes a right to a healthy environment. Regulatory dilution directly implicates this right. Precautionary principle conflict. Vellore Citizens Welfare Forum, 1996, mandates caution where environmental harm is irreversible. The height-based test risks exposing fragile zones. Public Trust Doctrine. Under MC Mehta vs Kamal Nath, 1997, the state is a trustee of natural resources. Narrow definitions enabling exploitation may breach this fiduciary duty. Implications of the stay. Regulatory pause on mining expansion. The stay halts immediate applicability of the 100-meter rule, preventing mining in lower Aravalli landforms until ecological and legal issues are finally adjudicated. Restoration of ecological safeguards. It temporarily revives earlier function-based protections evolved through Godavarman and MC Mehta orders that treated the Aravallis as an integrated ecological system. Judicial reassertion of oversight. The court signals that environmental governance cannot be driven solely by executive convenience and remains subject to continuous judicial scrutiny. Strengthening constitutional scrutiny. The stay allows reassessment of the definition against Articles 14, 21, 48A and 51A(g), reinforcing the link between ecology, equality and the right to life. Federal flexibility preserved. States retain the space to apply stricter, region-specific safeguards, preventing a uniform definition from weakening local environmental protection. Way ahead, adopt function-based ecological criteria. Aravallis should be defined using slope, geomorphology, hydrology and biodiversity, reflecting ecological role rather than a single elevation threshold. Codify scientific mapping. The FSICEC scientific methodology should be given statutory backing under the Environment Protection Act, 1986 to ensure uniform, evidence-based regulation. Embed the precautionary principle. Any reclassification must follow cumulative impact assessments, recognizing that ecological damage in fragile landscapes is often irreversible. Strengthen single-window governance. Bodies like the Delhi Ridge Management Board should be empowered with clear authority and NGT oversight to avoid regulatory fragmentation.